today's webinar presented by the Insurance Defense Group at Kelly Santini in Ottawa. Let's see, what time is it? It's noon right on. So I'm going to talk really slowly because I'm always late. And so I empathize with people who are going to be late. So I'm going to give you a couple of minutes to sit down and get your lunch in front of you and get ready to enjoy our webinar. We're in our in-house webinar studio, otherwise known as Signing Room 3. Yeah, it's not as exciting as it sounds. Today's webinar, we're reviewing 4 interesting insurance rulings from 2017. Our presenters will present the arguments for both sides of the case. And after each side has been presented, you'll get to be the judge and tell us how you would rule in each case. And so we're going to do this via an online poll. The poll will appear on your screen and you can vote using your mouse. Today's presenters are Samantha Iturregui, Allison Russell, and Crystal Schulz. Samantha is always fully prepared, and she is very adaptable to any kind of argument that she may have to make. In the 10 years she's been called to the bar, she's been defending MVA, slip and fall, property claims, major flood and fire claims, and she's earned herself a very good reputation. Insurers. Her tireless commitment keeps claims moving towards resolution. She's frequently mandated to negotiate settlements on behalf of her clients, and she provides coverage opinions, and she's acted on subrogation claims as well. She's pretty much done it all, it says here, from what I can read. And so Samantha is at ease with both English and French, and it says here she's been using her power of persuasion since winning her first public speaking grade 3.
That is true. Very true.
Do you still have the trophy?
I do.
Great. Since then, she's been appeared before small claims offenses court and the Court of Appeal, and she's also made an appearance at the Supreme Court of Canada, which resulted in a unanimous decision in her client's favor. She would like us to remember. Crystal Schulz here. Crystal, as you can see, is on my left. That's a joke. Crystal's on my left. She's insurance defense files for a very long time as well, whether it's a routine slip and fall or an MVA or complex fire loss or long-term disability claim. No detail is too trivial, no plaintiff too unusual or challenging. Crystal starts each file by taking a fair and reasonable approach. She digs deep to uncover elements of a claim in the outcome, takes the time to carefully assess her cases, develops strong, persuasive arguments to outline her client's position. And I can say personally, Crystal is one of those people who, if you have a whole lot of documents that you want to be turned into a simple, straightforward, she is great. Worked with her a number of times. I can tell you she's a great if you're defending a claim. And Allison Russell is here as well, and she focuses on commercial construction and general litigation. Always prepared to devote the time and energy needed to advance her clients' interests, providing prompt advice in order to guide clients toward a fair resolution. Allison is, because she has a construction background, property matters. She also does liens, trust claims, delay claims, contractual disputes. And she too has been at small claims, provincial offenses court, Superior Court of Justice, the Divisional Court, Court of Appeal, and the Supreme Court of Canada.
Allison and Samantha were actually together at the Supreme Court of Canada.
Oh, were you? Were you guys against each other?
We were co-defendants.
We were co-respondents on the same case.
Ah, there you go then.
So we both won.
So there you go. So you got the pictures of the 3 of them. That is exactly the way they look today. They're dressed in the same outfit. So you can, you're also able to send in questions to us using the dialog box on your screen. We'll save some time at the end to answer questions if we can. You can also download copies of our slides. And if for some reason that does not work, please send us an email and we will send the slides along. My name is Mitch Kitagawa. There you go. That's a whole lot of Mitch. What is up with his hair? Anyways, I'll be moderating today's presentation. So let us get to our first case. This is called Usinovich versus Pencorp Life Insurance. And Samantha and Allison are going to argue this one. I'm going to give you the facts. It's a Court of Appeal case in which the plaintiff was injured in 2007 when he fell from a roof while working. I imagine that hurt. He received disability benefits, but those benefits were discontinued in November 2011 when his insurer determined he no longer had a total disability. In January 2012, the insurer sent a letter to the plaintiff explaining its position. The plaintiff did not commence his action until April 2015, arguing that his claim was not time barred as the insurer's duty of good faith and fair dealing obliged the insurer to advise him of the applicable limitation period. So I believe we will start off with Samantha.
Yes, thank you, Mitch. I just want to start off to say that you members of the audience here are by far the smartest and the best looking group of judges and jury members that I've had the pleasure of appearing before today. So thank you all for joining in. Now, in relation to this decision, I'm going to be arguing on behalf of the plaintiff and the appellant in this matter. We all know that an insurer must act in good faith when they're dealing with their insured. Insurers are intelligent, they're well informed, and they're well aware of limitation periods which apply to their claims. The courts have recognized the duty of good faith of insurers when handling claims, and the duty includes acting promptly. It includes acting fairly when investigating claims, assessing and attempting claims. And an insurer must not deny coverage or delay payment in order to take advantage of the insured's economic vulnerability or in order to gain bargaining leverage. In addition to those duties, the insurer must inform its insured of the nature of the benefits available to them. And it is the position of the plaintiff that in the spirit of good faith, the insurer must also be required to inform its insured of a limitation period. Now, the insurer in this matter sent a letter to the insured in 2012, and in that letter, the insurer advised the insured that he would not be receiving benefits. He would no longer be receiving benefits. And in that letter, the insurer could very easily have added a single line advising the insured of the limitation period. Instead of doing that, in this case, the insurer only advised the insured of a 60-day period in order to file additional supporting documentation. Why would it not have also advised the insured of the 2-year limitation period for litigation at that time? Was this information intentionally from the less sophisticated insured? I think it was. Had the insurance company told my client about the limitation period back in 2012 when they claim, my client would have brought the action earlier and we wouldn't be discussing this matter here today. Now, keeping in mind the fact that an insurer has to act fairly when dealing with its insured, wouldn't it not be expected that an insurer should advise an insured about the limitation period when denying its claim or when discontinuing benefits? I think it would. An insured cannot be expected to know a limitation period on their own. Therefore, it is our position that the limitation period in this matter did not and should not begin to run until the insurer gave notice of its existence. In the alternative, if the limitation period did begin to run prior to giving its notice, then it is our position that an insurer should not be allowed to rely upon said limitation period. The insurer's failure to inform the insured of the limitation period should preclude it from relying on the limitation period as a defense. Now, honorable judges and members of the jury, we concede that there is no statutory obligation in Ontario for an insurer to advise an insured of the existence of a limitation period. We do note that said obligation does exist in BC and in Alberta. However, it is our position to you here today that the obligation in Ontario flows from the common law. Cases have found that insurers must give as much consideration to the welfare of the insured as to its own interests, given that the insured is typically in a vulnerable position when they're making a claim. And therefore, they should have advised the insured in this case of the limitation period. Those are my submissions, honorable judges and members of the jury. I'm confident that you will agree with me and that the argument that my friend is about to make holds as much water as a sieve. I would also like to remind you that my friend is on the side of the big bad insurance company, who, as I'm sure you already know, has very deep pockets.
Thank you, counsel. Ms. Russell.
Good afternoon, judges and members of the jury. I represent the respondent in this appeal, Pencor Life Insurance Company, the appellant's disability insurer. While I will agree that there is an obligation on the part of an insurer to inform an insurer it's available under the policy, that is not the issue here. The issue here is whether an insurer's duty of good faith owed to an insured is extended to require an insurer to disclose information outside of the policy. In other words, are they obligated to advise the insured of the existence of a limitation period? I say that they are not. There is no obligation for an insurer to advise an insured of the existence of the limitation period for the following reasons. Mr. Yusinovich was a self-employed eavesdrop installer. In 1999, he bought a policy from my client insuring him against disability arising from accidents. Or he bought additional coverage for disability arising out of sickness. In September 2007, Mr. Yusinovich fell from a roof and suffered serious injuries. He received benefits until November 2011 when my client terminated its payments because Mr. Yusinovich did not have a total disability as defined by the policy. On January 12, 2012, my client wrote to Mr. Yusinovich to advise that since he had been paid for 24 months, he was not entitled to receive any further benefits unless he was unable to engage in any and every occupation for which he was reasonably fit by reason of his education, training, and experience. My client also wrote to advise that Mr. Yusinovich's medical file did not support the conclusion that he had a total disability, and that the surveillance was inconsistent with Mr. Yusinovich's claim as to what he was suffering. The letter clearly stated, if you disagree with this decision, please submit within 60 days of receipt of this letter records in support of your claim for total disability from any occupation for which you are reasonably trained and educated. So contrary to my friend's submissions, it was clearly laid out for Mr. Yusinovich what his options are and what he had to do in order to try and continue with benefits. Mr. Yusinovich did not provide any new medical records. Although he claimed to have responded to the January 12th letter, my client never received that letter. Mr. Yusinovich admitted to knowing that his benefits had been terminated, that he had received the letter from my client dated January 12th, that he had read the policy, and that he had discussed it with his wife. He also admitted that he had considering hiring a lawyer at that time, but that he could not afford to do so, and so he did not further investigate. In early 2015, Mr. Yusinovich consulted with a lawyer who told him that there was a 2-year limitation period on his claim. Mr. Yusinovich alleges that if my client had told him about the limitation period, he would have brought that claim earlier. Instead, he commenced the claim in April 2015, more than 3 years after the benefits ended in November 2011, and 3 years after the January 12, 2012 letter from my client. Mr. Yusinovich is arguing that my client's duty of good faith and fair dealing obliged it to advise him of the limitation period, and that the notice period did not begin to run until my client provided him with that notice. In other words, it's my client's failure to inform him of the limitation period that precludes my client from relying on the limitation period. However, Mr. Yusinovich has conceded that there is no statutory obligation in Ontario on an insurer to inform an insured of the existence of a limitation period, but argues that that obligation can be imposed through common law. But, and as my friend did not raise with you, there are no Canadian cases that have gone so far to impose such an obligation on an insurer as part of its duty of good faith. In fact, in 2003 and 2008, the Court of Appeal of British Columbia had found that an insurer is not obliged to advise an insured of the limitation period. My friend did submit the fact that both BC and Alberta legislatures have passed legislation requiring notice of the limitation periods. But, and importantly, the Ontario legislature has not passed any such legislation. In addition, the plaintiff's proposed expansion of the duty of good faith would effectively judicially overrule the provision of the Act by making the notice to trigger the limitation period, and by making the notice the trigger for the limitation period and not the discoverability of the claim. This would result in ambiguity rather than clarity. For all of the above, it's my submission that the court should not impose a duty to inform the insured of the limitation period where the legislature has already declined to do so.
Thank you, counsel. Well, folks, now's the time for you to become the judge. So you'll see on your screen, question, how will you rule in this case? A, the insurer has a duty of good faith and must tell the insured when the limitation period expires. B, he should not have been working on a roof to begin with, as that's just dangerous and could lead to injury. Therefore, he should not be entitled to benefits. C, the insurer and insured should agree on the limitation period upon consultation with each other. Or D, the insurer should not have to inform the insured when the limitation period expires. So you'll get to vote, and I think the results are going to show up here. While we're waiting, Allison will sing for us. Keith, our chief engineer, is working on this. He's like Scotty from Star Trek.
Does Scotty keep his fingers crossed, hoping everything worked?
Of course.
All right. We have 85% voted, so why don't we close the poll? It's actually pretty close.
Okay.
We'll share that with everyone.
Here are our results. Let's see. D, insured does not have to inform when it expires at 50%. Close. A, must tell the insured when the limitation period expires. 2%, he should not be entitled to benefits. And no one got, they should agree on a limitation period. I like the 2% who said he shouldn't have been entitled to benefits. A couple of jokers in the room, or at least one anyways. All right, so our answer is D. So what the court found was that while British Columbia and Alberta's legislatures had imposed a positive duty on insurers to advise of statutory limitation periods in some circumstances, Ontario's legislature had not gone so far. The Court of Appeal agreed with the motion judge's conclusion that this was an issue best left for Ontario's legislature to regulate, concluding that the consequences of the appellant's proposed expansion of the duty of good faith are significant and would effectively judicially overrule the provisions of the Limitations Act 2002. This would defeat the purpose of the statute and bring ambiguity rather than clarity to the process. So chalk one up for Allison.
And I'll fix that typo before we send this out to everyone afterwards.
Where's the typo? I can see it. All right. We're going to move on to our next case, and this one's going to pit Crystal versus Allison. This is called Wilk versus Arbor. And this is a dog case. Zeus is a 9-year-old Great Dane owned by the appellant Kevin Arbor. On the morning of December 28, 2013, the respondent, Donna Marie Wilk, who at that time was in a romantic relationship with Kevin Arbor, offered to take Zeus for a walk, and Mr. Arbor accepted her offer. Although Ms. Wilk had walked Zeus before, she had always done so with Mr. Arbor. During their walk, Zeus, who was on a leash attached to his collar, suffered a seizure and became unconscious. To regain consciousness, he backed up, came out of his collar, slipped on ice, fell down an embankment and into a ditch. Ms. Wilk tried to retrieve Zeus, but also slipped into the ditch. She collided with Zeus, and Zeus bit her thumb, causing her to lose her thumb above the joint. The facts are kind of funny, but I hate to hear anyone getting injured. Ms. Wilk brought an action for damages for her injuries under Section 2 of the Dog Owners Liability Act. And so we'll have, who's going first?
I'm going first.
All right. Crystal Schulz.
Ladies and gentlemen of the Court of Appeal, I represent Kevin, the appellant in this appeal. Kevin is a hardworking elevator mechanic. His job sometimes requires him to be away from his house for long hours at a time. Kevin and the plaintiff were dating for about a year before this incident took place. They spent every weekend together, either at Kevin's farm or at her place in Toronto. The plaintiff was well acquainted with Kevin's dog, Zeus. The dog was always at the farm when the plaintiff was there. When Kevin spent time at the plaintiff's place in Toronto, Zeus accompanied him. In fact, the plaintiff cared for Zeus while Kevin was at work. Specifically, the night before the incident, Kevin had to work a 20-hour shift. That poor guy, he worked so hard. During that time, the plaintiff had full care and control over the dog. She kept him company, she fed him, she played with him. Poor Kevin, he arrives home in the wee hours of the morning. He's exhausted after his long shift. The plaintiff, they had been together for a year. She recognized how tired he was. She offered to walk Zeus so that Kevin could sleep. It was during this walk that she was injured. My dog-hating opponent would have you believe that Kevin, who was asleep in bed after a long, hard night of work, was responsible for the plaintiff's injuries. She would like you to believe that the plaintiff bears no responsibility for the dog or for her own injuries. The Dog Owners Liability Act liability on the owner of a dog who causes injuries. And we can see that the plaintiff did not own the dog, but that's not the end of it. The Act defines owner to include a person who possesses or harbors the dog. The word possess, and I looked it up in the dictionary, means actual control or visible power or control. So on the morning of December 28th, 2014, the plaintiff offered to walk the elderly dog so that her boyfriend could get a few hours sleep. She gathered the dog's 4-foot leather leash, clipped it to his collar, and set out on the walk. By doing so, she assumed full control of the animal. If the dog had attempted to bite another person or animal on that walk, the plaintiff would have been in the best position to control the dog. Not Kevin. He was asleep in bed. The Dog Owners Liability Act was enacted to make the person who is able to exert a measure of control over the dog responsible for the animal's behavior. So the critical time to establish who possessed or had control of the dog is the moment just before the incident occurred. It's not who the dog lived with. It's not who regularly fed and cared for the dog. It's the person who had possession and control over the dog in the moments before the bite. That was the plaintiff. Kevin was not negligent. He was asleep. He had no control over the dog at the time of the bite. Poor Zeus had a seizure. He was disoriented. He fell down an embankment, and as he was trying to recover, the plaintiff fell down the embankment and landed on top of him, likely causing significant pain to the already traumatized dog. While we sympathize with the plaintiff and the injury she suffered, this wasn't Kevin's fault. Do the right thing. Vote thumbs up for Zeus and his owner, Kevin.
Thank you, counsel. Ms. Russell, in response.
Honorable judges of the Court of Appeal, I would like to start by making it clear that Donna's relationship with Kevin had its ups and downs, its highs and lows.
Grown.
But this was the absolute bottom when Donna lost her thumb to Kevin's dog. My friend would have you believe that it was Donna who was the owner at the time of the accident. However, I submit that the purpose of the legislation is to impose responsible dog ownership and to interpret the act to interpret the act as proposed by Kevin's lawyer would void that intention. Donna was not in possession of the dog at the material time for the following reasons. Zeus had belonged to the defendant for about 6 years at the time of this incident and had lived at Kevin's property. Kevin controlled Zeus's activities. Given Zeus's medical conditions, Kevin cooked Zeus's meals in advance and administered medication for his seizures. On the day before the incident, Kevin instructed Donna to feed Zeus at 6 p.m. She followed his explicit instructions. On the day of this incident, Donna asked Kevin for permission to take Zeus for a walk. This was the first time that she had taken Zeus for a walk alone. Donna did not exercise any control over Zeus without Kevin's direction or approval. Section 2(1) of the Dog Owner's Liability Act reads as follows. The owner of a dog is liable for damages resulting from a bite or attack by the dog on another person or domestic animal. To find that Kevin was anything but the owner and that Donna was anyone other than someone who had suffered from a bite or attack by Zeus would be contrary to the intention of the Dog Owner's Liability Act. Even if the Dog Owner's Liability Act does not apply to the facts of this case, the facts as set out above do still impose liability on Kevin in negligence for Donna's injuries. There exists an ordinary duty of a person to take care that their own animal does not become a source of harm for animals. A source of harm to others. The defendant, Kevin, was aware that Zeus was more likely to suffer a seizure after missing a meal. Kevin knew that Donna would only feed or medicate with his specific instructions. She didn't know any better. Kevin did not provide to Donna the suitable or proper fitting for the collar for Zeus, which he was wearing during the walk, which was what led him to fall down into the ditch. For all of the above reasons, it is Kevin's responsibility for Donna's injury. My friend asks you to give 2 thumbs up to Kevin. There are only 1 thumbs in this case, and you need to give 1 thumb down for Donna.
Yeah. Good thing we're lawyers and not comedians. All right, folks, it's time for you to become the Court of Appeal and vote. So how would you rule in this case? A, the defendant was liable for the injuries. B, the dog was liable for the injuries. C, the incident was unforeseeable. As such, there was liability on the defendant. Or D, the defendant.
There was no liability on the defendant.
Sorry, yeah, there was no liability on the defendant. D, the defendant should have swiped left. I still don't know what that means, I swear. So we're gonna open the polls. Go ahead and make your choice. And then as they're tabulating, we get to see the votes coming. We don't know who's voting. We get to see the votes pile up as they come in. So it's exciting for us. I don't know how you guys feel about it. All right, Keith, where are we at?
80% have voted. All right, let's close this up. Most people have had a chance. I think the other 18% just can't decide.
Maybe they've fallen asleep.
There are the results.
All right, and the results are, let's see. The incident was unforeseeable. No liability on defendant. At 73, and then 24, the defendant was liable for the injuries. The dog, that's the same person who put that on the other one, right? There's a joker there. We will find you. All right, well, here's what the Court of Appeal said. C was the correct answer. The plaintiff, by being in physical possession of and having control over the dog just prior to the incident, was in possession of the dog. As such, the plaintiff was not entitled to damages under the Act. On the issue of negligence, the Court of Appeal dismissed the plaintiff's cross motion and upheld the motion judge's finding that there was no negligence. So Allison loses again. I mean, Crystal won.
I think Allison won the last one, I think.
I think I did by 2%.
You
Sorry,
did,
okay,
yeah.
Oh, true enough. Okay, we're gonna move right along here to Nemchin versus Green. And this is gonna have Sam and Crystal providing their perspectives on it. I'll give you the facts. The plaintiff's claim arises from a motor vehicle collision. The plaintiff alleges suffering from post-traumatic stress disorder. At the examinations for discovery, the defendant said there was no surveillance. After examinations, surveillance of the plaintiff was carried out in the spring of 2015, and the existence of that report and the related video were disclosed to the plaintiff in that summer. Surveillance was next carried out in the fall of 2015. The existence of the second report and video were disclosed to the plaintiff soon after it was done. A third round of surveillance was conducted in May 2016, and through inadvertence on the part of counsel for the defendant, the existence of that surveillance was not disclosed to the plaintiff until January 30th, 2017. Each of the three surveillance reports produced identified that the video had been edited and that an unedited version of the surveillance had been placed in storage for retrieval at a later date if necessary. On the Friday, immediately preceding the Monday on which the trial was scheduled to commence, counsel for the plaintiff made a request for production of the complete unedited videos of the surveillance conducted in 2015 and 2016. The unedited videos were produced in as timely a manner as was possible early in the week of February 13th, 2017. The plaintiff sought to have the surveillance video excluded at trial. So arguing for the plaintiff is Chris.
I'm arguing first for the defendant.
Oh, sorry, for the defendant. Sorry.
Yes. Good afternoon, Your Honor. As you know, this is a mid-trial motion to determine if the surveillance video obtained by my client, the defendant, should be introduced as evidence at the trial. While we acknowledge that the surveillance was produced only a few weeks prior to the trial, this was done through inadvertence, not malice. There was certainly no attempt to have a trial by ambush. In fact, as you're aware, 2 other surveillance videos taken in the years before the trial have already been produced. We submit that there was plenty of time for the plaintiff's counsel to review the video and address any prejudice the short service may have caused. I know when surveillance lands on my desk, it's the first thing I look at, and I anticipate that the plaintiff's counsel is no different. If, as they say, a picture is worth 1,000 words, a video tells a story. Your Honor, the jury will want to see this video. You've heard the plaintiff's evidence up to this point in the trial as to how she spends her days and her description of her limitations and level of functioning. Contents of the video are directly relevant to the plaintiff's claim for damages. The video footage contradicts her evidence on the extent of her physical limitations, her psychological impairments due to post-traumatic stress disorder, and a reported lack of comfort with driving. The plaintiff says she has constant back pain, but is seen walking, sitting, standing, doing yoga, driving, and bending over to pick stuff off the ground. She's seen walking in the heavily trafficked areas, which contradicts her evidence that she's easily startled, wary, and hypervigilant around traffic. The surveillance does not show someone who can't sustain gainful employment. As you're aware, the 3-part test for having the surveillance admitted requires a video to be 1, verified, 2, accurate, and 3, fair with no intention to mislead. With respect to the first point, verified, you have heard from the investigator who took the video. The investigator is a trained and certified professional. He's not some pervert hiding in the bushes with a zoom lens. This is his job. With respect to the video being accurate, the investigator gave his evidence to explain his methodology, the equipment he used, and his usual surveillance practice. Both the edited and the unedited versions were produced, and they are substantially the same. This is accurate footage. With respect to the last point, the video being fair, this is a fair depiction of the plaintiff's actions. It's a video. It shows what she was doing. How could it not be fair? There is no intention by the investigator, by way of editing or commentary, to mislead the viewer. While I grant you that the investigator uses colorful commentary in his descriptions and included some personal observations, that doesn't make the video unfair. He was overzealous. It wasn't his intention to mislead. He was simply trying to make the written report come alive. The video demonstrates the plaintiff's functional capabilities and should be admitted. The jury should be able to review the video and make a determination on the plaintiff's functionality with all the evidence before them. The jury won't know if the plaintiff is observed to be doing cartwheels down the road or aerobics at extreme trampoline unless they're given an opportunity to see the video. The probative value of the video outweighs any prejudice that may have been caused. Your Honor, the jury needs to see this video, and they should see the video.
Thank you, counsel, for making that presentation come alive. Ms. Iturregui for the response.
Well, good afternoon, Your Honor. Firstly, I'd like to say that not even Donald Trump would agree with the alternative facts set out by my friend here before me today. The real truth of the matter is that this video surveillance is neither accurate nor is it representative of the actual abilities of the plaintiff. Therefore, it should not be admitted as evidence. These investigators, if we must call them that, were hired by the defense to follow around a poor, injured plaintiff without her knowledge, and the defense failed to tell us about it until the eve of trial. Put yourself in my client's position for a minute and think about what an investigator would observe you doing if he followed you around for days at a time. Now, there is clearly a bias when the filming is going on because they are trying to obtain footage of the plaintiff to prove that she can do things that she says she cannot. The footage is then edited by the support staff at the investigator's office to show only the best parts. I think my friend used the term to make the video come alive. The boring and unhelpful parts are deleted, and the frames are changed and enhanced to accentuate the defendant's position. Your Honor, you are not seeing the raw footage here, and there are gaps in this video. Further, the commentary made by this investigator in the surveillance reports only further confirms his bias. And the still shots chosen by his staff for this report show an image that doesn't accurately depict the full extent of the plaintiff's abilities. The witness admitted that the purpose of the support staff in selecting the still shots was to find evidence that, in quotation, most describes inconsistencies between the plaintiff's claims and the activities depicted in the footage. This footage, Your Honor, is an exaggeration of the plaintiff's activities, and the lack of probative value versus the huge prejudice it would cause if it was presented to the jury makes it such that it should not be allowed. Thank you.
Thank you, counsel. All right, folks, time to vote. Was the surveillance, did it meet the test of being verified, accurate, and fair? And so there you have your results. Your suggested answers. Was the surveillance or the surveillance did not meet the test, was not served on time as A. B, surveillance was served in a timely manner and met the test. Met the test, so it's admissible. Surveillance was just so damn boring, no one cared about it anyway. Surveillance was admissible, but the plaintiff was entitled to take a break during cross-examination to consult her lawyer. So
I'm anxious to see what these results are.
All right, so our voting is now available. I like the line about the, what was it? Pervert in the bush. You said they weren't. I want to know, how do you know? Very persuasive argument, though, depending on who your judge is.
All right, everybody's, most people have had a chance to vote.
All right.
And we're
going to close the poll and tally our results here. And let's see, surveillance did not meet test, not served on time. It looks like the winner in second place would be surveillance served in a timely manner, met the test and was admissible. Well, the actual answer is A. The court found that, I quote some of this, given the interests of fairness and the objectives of efficiency and settlement, the court expects the parties to comply fully and rigorously with the disclosure and production obligations under the rules. In the matter before me, it was through inadvertence that the surveillance report and video 2016 were not disclosed until 2 weeks prior to the date on which the trial was scheduled to commence. I equate that inadvertence to less than full and rigorous compliance with the disclosure and production obligations under the rules. The court should not reward non-compliance with the disclosure obligations under the rules. It was not reasonable for the defendant to expect the plaintiff in 2 weeks prior to and during the first week of a multi-week trial to be able to address the prejudice arising by reason of disclosure and production on January 30th, 2017 of the 2016 surveillance evidence of which the plaintiff had no prior knowledge. So the surveillance was not allowed into the action. I understand that it's It's under appeal. And I don't know if anyone's heard of whether there's been a result yet.
I don't think there has been. I have not heard of one.
No. Okay. So stay tuned. That'll be our webinar next year. All right. So we're going to move on to another case. This is one where we're going to talk about what constitutes an accident. This is a LAT decision. You can see it's a 16- number versus Aviva Insurance. This one has Samantha and Allison providing their sides of the argument. I'm going to start with the facts. It was a 7-year-old girl at the time, a student in elementary school. She suffers from cerebral palsy. She is confined to a wheelchair, has special needs. She is fully vocal, but her CP causes her speech to be affected by stress and anxiety. The applicant was transported daily to school by a school bus driver. On April 16, 2009, the driver arrived with the school bus at the applicant's home. She loaded the applicant into the bus. The applicant was the only child on the bus. The driver did not deliver the applicant to school. Instead, the driver drove her to her own, that is the driver's house. The applicant was aware that the driver was taking an abnormal route. This caused the applicant to become anxious and frightened, and she became short of breath. When she's scared or anxious, she has difficulty communicating with words that are understandable. The applicant became increasingly anxious when the bus entered and stopped on the driver's driveway. The driver then exited the bus, locked it, got into another vehicle, and drove away. There were no alarms on the bus that the applicant could trigger. By the time the driver was notified by her dispatcher that the applicant had not arrived at school, the applicant had been left on the bus alone and unattended for approximately 2 hours, during which time her psychological status deteriorated. The applicant claimed to have sustained psychological and mental injuries and impairments as a direct result of being abandoned on the school bus. The applicant filed an application for auto insurance dispute resolution at the tribunal with respect to denied requests for accident benefits, as it was not an accident. And so the question is, was this an accident pursuant to the SABS? Allison?
Good afternoon. I think there are few among us who haven't experienced bumping along in a big yellow bus to and from school as a child. There is no doubt that this is an ordinary and well-known activity to which vehicles are put. Section 3.1 of the Statutory Accident Benefits Schedule defines accidents as an incident in which the use and operation of an automobile directly causes an impairment or directly causes damage to any prescription, eyewear, denture, hearing aid, prosthesis, and other medical or dental advice. What's important for us is in which the use or operation of an automobile directly causes an impairment. Whether or not my client was involved in an accident as defined requires consideration of both the purpose test and the causation test. The purpose test, which was first set out in the Supreme Court of Canada decision of Amos and Insurance Corporation of British Columbia, is whether the accident resulted from ordinary and well-known activities to which automobiles are put. Clearly, we can put a check in that box. This was an ordinary and well-known activity to which vehicles are put. The purpose test has been met. The causation test is a two-part test which requires the consideration of whether the use and operation of the vehicle was a cause of the injuries. In other words, the but-for test. And if the use and operation of the vehicle was a cause of the injuries, was there an intervening act or acts that resulted in the injuries that cannot be said to be that could not be said to be part of the ordinary course of things? There is no doubt, but for this particular school bus ride, on that fateful day, my client would not have sustained the psychological and mental injuries that she did. Again, we can put a check in that box. The but-for test has been met. With respect to the second part of the causation test, which is if the use and operation of the vehicle was a cause of the injuries, or whether there was an intervening act or acts that cannot be said to be part of the ordinary course of things. I submit to you that there was no intervening act from a new and independent source when the bus driver abandoned my client. The driver was still in the process of completing this activity when this young girl sustained her injuries. When she was abandoned on the bus, the use and operation of the school bus continued despite the absence of the driver. In addition, this young child with special needs expected to be taken from her home to her school by the bus. She knew that the bus had veered off route. She knew that it was going somewhere other than her school. And her anxiety continued to grow as she realized that she was not en route to school, but she was not able to communicate that because of her anxiety. Once the bus stopped at the driver's home, it was a continuation and an escalation of the anxiety that had started when she knew that the bus had veered off route. The chain of events that brought about my client's injuries was the school bus pickup at her home, the bus going off course, and her abandonment at the driver's driveway. The trip was in progress and the bus was being used for its ordinary course. There was no intervening act that could be said to be part of the ordinary course of things. Accordingly, it's my submission that we have met the last part of the causation test, and we can put a final check in the final box. All boxes having been checked, I submit to you that there is a clear entitlement by my client to the statutory accident benefits for the injury she suffered while riding her school bus.
Thank you, counsel. Ms. Iturregui.
Well, I have to start today by saying that my friend's argument reminded me a lot of a vacuum cleaner because it sucked. I feel like that joke went too far, but there we go.
I feel like it went too far.
Probably.
I take it back.
Never stopped before.
Now, I'm sure you would agree with me that forgetting a child on a school bus is not part of the ordinary use and operation of the bus. Come on, I'm not sure that any responsible parent would allow their child to get to school this way if it was. And no matter how badly the court feels for the child or how badly the court wants to provide this child with compensation, to find that this incident meets the definition of a motor vehicle accident and that the plaintiff is entitled to ABs defies logic. We all know that courts never defy logic to find in favor of a party they sympathize with, right? So, had the child been injured during the loading or the unloading of the bus, then her injury could have been said to have occurred during the ordinary use and operation of the bus. However, abandoning a child on a bus does not fall within the ordinary use and operation of the vehicle. The ordinary use and operation of the vehicle ended when the vehicle was parked. The driver leaving the bus and the child remaining on the bus is, I submit, the intervening act. Much like the Chisholm case, where it was found that the fact that a gun was fired from a vehicle and injured another was not an accident and did not occur during the ordinary use and operation of a vehicle, and therefore did not entitle the injured party to ABs. This situation is similar in that the act was not the use and operation of the bus, but abandoning the child on it. The direct cause of the injuries in this case are not the use of the school bus. Thank you.
Thank you, counsel. I appreciate your come on argument.
I thought you'd like that.
All right, so it's time for you to become the judge and decide how you'd rule in this case. Your options are A, this was not considered an accident. B, this was considered an accident. C, accidents will happen, but it was not negligence. D, that bus driver must have received her customer service training from United Airlines. So let's open up our voting. There we go, it's been launched. So go ahead and vote. And we'll see what you think of counsel's brilliant arguments. Come on.
Come on. Come on. Vote for A.
Are you kidding me?
Who's buying lunch today?
Yeah, we should introduce a betting component into this.
Oh,
right?
that's good. Our next one. We should have stakes.
All right. B, this was considered an accident, 62, and A, this was not considered to be an accident. And the correct answer was? Oh, I see we have our joker.
2%.
Yeah, nice. Which I'm pretty sure is one vote, right? Yeah, the answer is B. This was considered an accident. Here's what the court said. The applicant had been picked up but not yet delivered to school. It seems self-evident that she continued to use the bus for its ordinary purpose because she had not yet arrived at a regular destination nor been removed from the bus. If the cases provided by both parties hold that accidents, by definition, can occur during the loading and unloading of passengers from vehicles, could the reverse not hold true as well? That the driver failed to unload the applicant, a procedure well within the ordinary use and operation of a vehicle, and thereby cause her injury? The start of the applicant's distress and mental deterioration occurred while the bus was still transporting her to school. The psychological injuries were triggered as soon as the bus left and the applicant recognized the deviation. She started to become anxious and frightened and have difficulty with communication. Being left on the bus only exacerbated the already existing injuries. So there you have it. And that is our final case. So now I understand that if you have any questions, you can put some questions in, and if only I could read them.
Oh, well, first questions come in. Was Zeus okay?
Zeus survived.
Zeus is still going.
Well, I don't know. He was on some pretty heavy medication. He was actually on anti-seizure medication, and part of the thing that were disclosed were that he wasn't given that medication prior to the walk. And so that's why he had the seizure going into.
Yeah, he was on prednisone or something.
Yeah, he was.
Yeah.
And then
Prednisone. Crazy.
and then the person, the woman who fell down, I forget the facts, sort of said that when she fell down and hit Zeus, her thumb fell into the dog's mouth.
Yeah.
That was part of it. So anyways, so we think Zeus is okay.
Just a couple of inquiries about copies of the presentation. If you are unable to download it, which has happened in the past, yes, email, and we will happily send you a copy later today. And another question, is this going to be available online? Yes, it has been recorded. It should be up on the firm's YouTube channel, accessible through the website Monday. And I think we're done. No specific questions, so
No.
We are good.
Great. Well, thank you, Samantha, Allison, Crystal, and for hearing skills and for arranging everything. Great job, Keith. Thanks, everyone. And we hope to hear, or we hope you hear us at our next webinar, which we will again advertise when the time is right. Thanks very much, everyone.
Have a great weekend, guys.